Lieutenant Solomon claims that he can demand identification because Arkansas is a stop and ID state, and Mr. McHenry argues that the Fourth Amendment prohibits officers from stopping and identifying anyone they want. As we have discussed before here on ATA, the Supreme Court held in the 1979 case of Brown versus Texas that officers requiring individuals to identify themselves absent reasonable suspicion to believe they are engaged in criminal conduct violates the Fourth Amendment. Although the Supreme Court also determined in the 2004 case of Heibel versus 6th Judicial District Court of Nevada that a citizen may be arrested for refusing to identify themselves in violation of a so-called stop and identify statute, the court clarified that the Fourth Amendment requires that officers have reasonable suspicion in order to demand an identification or arrest a citizen for failure to identify. Now, while Arkansas does not have a statute that explicitly requires a citizen to identify themselves during a stop, courts have determined that the state obstructing statute, which is codified in Section 5-54-102 of the Arkansas Code, permits an officer to make an arrest if an individual refuses to identify themselves and the officers have individualized reasonable suspicion of illegal activity. However,